Learned Council,
they are two separate things.
separation of powers is not restricted to the judiciary.
Yes.
What if the judiciary starts encroaching upon the powers of the legislature and executive? And that is how...
पांचवा डाल दें क्या फर्क पड़ता है? कोई फर्क पड़ता है?
So, I mean, there's a system of checks and balances as well.
Yes.
So the parliament is empowered to legislate, and all that they have legislated is something which ensures to justice.
That is what I will show when I come to provision by provision, that none of these provisions.
Can you elaborate a bit more on your second one? The court cannot colonize or abrogate the primary role of the Supreme Court to frame such.
My lord,
Kindly elaborate a bit more.
example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, the Contempt of Court Act 2012 did, is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of for example, a contempt on the face. In that, legislature interfered and that said that that case will go before another judge.
That's not practice and procedure. That's not
No,
practice.
but I'm saying that is that.
No, but Bas Kakar was decided in the context of Article 204.
No, I'm giving you an example.
But that was a different context. Give me an example of 191 when you say.
I'll give you an example.
Colonize or abrogate.
I'll give you an example. Let's take section 2. If there was any role.
आप जरा specific example नहीं, मुझे जरा पहले इस principle को जरा समझाइए.
वही मैं principle.
आपकी limitation
मैं
क्या
एक
है?
example से principle को. Let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I would say would be a violation of 191 and the principle of the independence of the judiciary.
I would regard section 2. I mean section 3 actually.
Section 2 sir committee जो बनती है, एक committee member chief
3 में है ना?
जी.
3 में है?
2 में है ना? 3 में तो वो है ना sir maintainability वाला sir.
Sorry, 2 में है. I would regard that as colonizing the.
I know your lordship comment about.
You've used very interesting words.
Colonization.
Colonize. तो colonize.
बस ये literature पढ़ के थोड़ी सी गलत
colonize हो गया ना इसको. इसलिए मैं आपसे ये you're making an interesting point. But I want you on the plane of principle kindly to this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggesting, that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
नहीं उसके अंदर.
The other way is that you keep the door open, but the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddiqui sahab,
ये जो आपने बात की है second, ये आपका जो second है, how does that square with the implied repeal? आपका ये जो second point है ना? Secondly, the court cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible.
Yes.
Kindly explain to me
Sir,
how. As a principle,
sorry,
principle की बात करें. I mean, don't go into the nitty gritty right now. वो तो आप आगे जाके करेंगे. मैं आपका principle समझ रहा हूँ. How does this square with the? You say there can't be express repeal, but how does this square with implied repeal?
No, sir, there can be express and implied. What Mr. Salahuddin argued that the parliament can get rid of the entire Supreme Court rules. I'm not advocating that on a particular rule.
How do we identify the core that cannot be repealed?
Yes.
Mr. Faisal, the core would be that in case, Mr. Salahuddin might be correct, you see, they can strike down the entire set of rules provided they don't violate the independence of judiciary. Your argument is the same.
No.
Why stand on any provision? No. Suppose theoretically speaking, if you bring out a law which takes away all the rules that are there, but it doesn't affect the independence of judiciary, maybe enhances the independence of judiciary, what's wrong?
My Lord, I think what is underlining 191, and this is something which should be safeguarded at all circumstances, is at the heart of 191 is not the law made by Parliament, but the internal autonomy of the Supreme Court.
There has to be some
Siddiqui
principle.
साहब, my question, please.
जी, जी, जी.
ये आर्टिकल 191 की जो लैंग्वेज है that starts with subject to the law in the constitution. There are very few articles of the constitution which starts with the word.
There are only three.
Only three. Yes. So does it means that because the constitution was framed in 1973 and the rules were framed in 1980, do you think that there is still a room is left for the improvement in the procedure with the passage of time? Like 184(3), whenever it has been used, ये पूरे मुल्क की बुनियादें हिला दी उसने जब भी इस्तेमाल हुए. So do you think there is a room left for improvement in Article 184(3) or the procedure of the Supreme Court?
My Lord, I think
Intentionally that has been done.
whatever amendments, and I'll take your ladyship through each of the amendments, whatever amendments have been done, I think that shows that reform is required under Article 184(3).
So can I just understand? आप ये कह रहे हैं कि 191 enables Parliament to make law.
Yes.
The principle to apply will be the independence of the judiciary. So the independence of the judiciary and the ability to make rules should be protected and preserved. But Parliament can make law with reference to practice and procedure.
Yes.
If they do make that law with reference to practice and procedure, so that's not undermining that principle of independence of the judiciary, but then we then go into the provisions that
Yes.
they'll start making of practice and procedure, and so then see whether that meets that. So then my question is that isn't the constitutional mandate the opposite? Isn't the constitutional mandate saying that the Supreme Court, to the extent of how it regulates practice and procedure, will do it itself, because that is in its own internal matter, and the only thing that's stopping the rule-making ability is anything expressly provided in the Constitution or by law. Like I said yesterday, limitation hai, court fee hai, is tarah ki cheezein hai, which are procedure related, which you can't override through your rules. So ek system bana hua hai, uske andar they govern themselves internally. And it's interesting that in these 3 days of hearings, nobody has actually said to the Supreme Court that this is your rule-making power. What is stopping you today from making these rules? And why don't you exercise this power and call a full court meeting and actually exercise this power and bring whatever change you think today is acceptable? We're ready to argue this point and go into the delicacies of subject 2 and whether this is an expansion of jurisdiction or not. और आपके मुताबिक तो Supreme Court appeal की right भी दे सकता है. So problem किधर है?
If appeal is read into as procedure.
The point is कि अगर हमने independence of the judiciary को guard करना है तो where is the limit? कहाँ guard करें? कहाँ guard करें?
Your ladyship is
What principle should I follow?
Your ladyship is absolutely right. There is nothing stopping the Supreme Court from reforming itself, but a much more fundamental principle is involved.
Faisal, इस पे एक example, just to quote an example, in Germany and in South Africa, they have adopted the concept of the lawful judge, and I'm sure you must be aware of that. और उसके लिए उन्होंने elaborate criteria laid down किए हैं कि how the cases are fixed and before which judges they will be fixed. So there's no intervention by any master of the roster. It's all through, if the Parliament tomorrow, in the interest of the litigants, legislates and on these lines, would they be competent to do that, and would that in any way, which protects the interest of the litigants, affect adversely the independence of judiciary?
Look, that is my precise point, that the issue is that does 191 create this delicate balance between preserving the internal autonomy of the court, but at the same time give a check and balance role to the legislature. That's the central point. That is why, regardless of whether there are internal reforms or not, The parliamentary role cannot be eliminated. But the parliamentary role, of course, has to come within the ambit of 191.
What would be the status of the Supreme Court in making rules in presence of this Act? Whether the Supreme Court can enhance power, make it committee from 3 to 5?
My Lord, the first thing is, and this goes back, connecting both your questions, goes back that in terms of these rules, of course, there are certain rules of the Supreme Court right now which are in conflict with these rules. Like Section 2 of this Act is in conflict with Order 11. The review, the right to counsel, new counsel, is also in conflict with that. The Order, I think, 27 or 37.
Take a stand, Mr. Siddiqui. Yes. Take a stand. Don't beat about the bush.
Yes.
Direct question has been asked to you.
Yes.
If tomorrow the full court says that this committee consists of 5 members, can they do it? Or will the law, this act be the, Section 2 be the constraining, limiting power?
Or is there any restriction in the Act?
Give a straight answer.
Sir, after this Act, I don't think there can be enhancement in terms of Section 2.
So that means the Act trumps the Supreme Court.
As far, because it doesn't, unless and until your lordships can, someone can challenge Section 2 on the ground that having a 3-member committee violates fundamental rights or the independence of the judiciary. If you can't challenge that, then enhancement.
Are the rules binding on a bench? Whoever makes the rules of the Supreme Court, are they binding on a bench of the Supreme Court?
Yes, I think that's the law. The rules would be binding.
On the bench itself?
Yes. Unless that particular rule is suspended through a judicial order.
No, on a bench. A rule made through administrative power, is it binding on the Supreme Court exercising judicial power?
Delegated legislation which is made under Article 191, I think. So I think the rule would be binding, and there are numerous judgments.
We are talking about now constitutional matters here.
Question is,
let me finish my chain of thought. There is a rule, whatever a rule says, a 3-member bench says that this rule, in our opinion, contravenes some fundamental right.
Yes.
Therefore, we will not strictly follow it. So surely it's not binding. Or are you saying that the bench cannot pass such an order?
No. I'm saying unless, if your lordship declared the rules as ultra vires or a particular rules, of course they are not binding. But unless that is...
now we take the discussion a bit forward. If a bench of this court states that the rules under 184(3) have not been formulated in the Supreme Court Rules 1980, and therefore matters, till such rules are made, such matters should not be fixed for hearing, excluding habeas corpus matters. Can such a bench pass such an order?
If there is a constitutional basis for it,
I'm just asking you a thing, yes.
My Lord,
184 at existing rules, I'm not talking of hypotheticals, I'm talking about the rules 1980 as they are. A bench of this court says, since 184(3) petitions have been filed, and the mode and manner of how they should be heard has not been determined in the rules, can a bench pass such an order?
Yes, a bench can pass such an order if the bench can show...
And can the bench then say, let the full court make such rules?
On the first part of the question, the bench can pass such an order if such a restriction can be inferred or is present in Article 184(3), that 184(3) powers cannot be exercised until rules are made. If the bench holds that rules, unless rules are made...
I'm saying if, no, I'm saying it has done it. Now, either you say it's not permissible or it's permissible.
If a constitutional basis can be shown for that, I think, of course.
Okay.
I mean, if the rules are violative of the Constitution...
There has been a case where a bench,
yes, I know,
very bench of this court said that the rule should be enacted by the full court.
Yes.
Now, if even exercising judicial power can be thwarted by saying, no, then how do you get the rules made? It all depends now on the person of the Chief Justice. So please explain that to me. I mean, why are we just skirting the issue, hypotheticals? Why are we not coming to actual practical things which are happening in Pakistan where cases have been decided and sort of all over the place? Just take the bull by the horns and ask the question.
I'll come to that. I'll just cite two judgments.
Judgments, I mean, I just want to know the clarity on this issue.
मैं वो खत्म कर दूं, 1 मिनट दीजिएगा मुझे, सिर्फ 1 मिनट. There are two judgments, if your lordship, and I will not read them because I've already...
You can just add to that. Parliament can't make it. A judicial order cannot ask for these being made. So at the end of the day, it is all power vests in one individual called the Chief Justice of Pakistan, and that is
That is exactly my next point, but I'll just, because I just want to hurry. There are three judgments which your lordship may look at. At page 5, the first judgment, 92 SCMR 1208. This is where I draw this principle, where Justice Ajmal Mia,
12?
Sir, Afzal sorry.
No, 120?
1202, where they say that we will not follow such statutory provisions and it will not override the rules which violate the independence of the judiciary. So this is where I draw that principle. There are two judgments.
But this judgment says that the rules will prevail
if
over the statute.
Yes, if the statute violates the independence of the judiciary. That's the criteria. But as a general principle, there are two judgments. One is from India, AIR 1964, Supreme Court 855. It's all written there, in which this conflict came before the Indian Supreme Court.
Where is it written in your booklet?
Page 5, top of
Sir, ये page 5 पे first 2 paragraph देखिएगा, और अगर ऊपर ही देखिएगा तो मैंने एक judgment दी है AIR 1964 Supreme Court 855, in which a conflict between a rule of the Indian Supreme Court as well as an act came, and they said the act.
I still don't know. You're going again around. Simple proposition is no. Sorry, you have to answer these questions. So all power vests in the Chief Justice, not in the full court, because full court is then dependent on whether the Chief Justice wants to call a full court meeting or not. The last full court meeting before the one that was called on 18th of September was about 4 years before. Prior to that, a lot of issues had accumulated which have still not been addressed through the full court meeting. So why are you hesitant in calling a spade a spade?
Sir, I'll answer that question now. My lord, the proposition which has been put forward, and this is one of my objections on the Ghulam Muhyiddin case.
फिर आप कैसे पे चले गए?
जी, सर
आप जवाब तो दे
मैं दे रहा हूँ.
तभी आप इधर चले जाते हैं.
That is the first
नहीं,
case.
हम नहीं,
मैं जवाब दे रहा हूँ.
आपको मैंने एग्जांपल दे दी है.
मैं जवाब दे रहा हूँ, प्रिंसिपल स्टेट कर दूँ.
अच्छा चले, मैं आपको बता देता हूँ. अब चलें, हम इस कानून को उड़ा देते हैं, ठीक है? ये इस कानून को हमने उड़ा दिया. ऐसी मफरूजा दे रहा हूँ, ये कानून उड़ गया, ठीक है? अभी कोई रूल बनाना, मैं नहीं फुल कोर्ट मीटिंग करता हूँ. आप करेंगे क्या, मुझे जरा बता दीजिए. नहीं, ये देखिए फैसल साहब, you are a highly acclaimed constitutional lawyer, so praising me or anyone else should not be a substitute for responding to a query. A constitutional query I'm asking you.
अभी यही क्वेरी आपका.
फिर आप इस केस में ले जाएंगे गुलाम मुहय्यिद्दीन में.
अब मैं कोई केस साइट नहीं करूंगा, आपके सवाल का जवाब दे. सर, the independence of the judiciary is not linked or is not threatened if the role of the Chief Justice is reduced. Now, that is not the principle. That I think
it took you a long time to say that.
Yes. No, I've written that here, sir.
You haven't said it.
Here. So this whole debate that the master of the roster must be the Chief Justice has been elevated to a constitutional principle. It is nowhere in any case law as a constitutional principle. As Mr. Salahuddin rightly pointed out, its whole basis is in terms of judicial history and in terms of statutory law. Ghulam Muhyiddin case is the first case which lays down that the Chief Justice, being the master of the roster, is linked with the independence of the judiciary. Your Lordship will find no case which makes this link. The link has always been with the independence of the judiciary linked with the Supreme Court itself, not with the particular...
Professor Siddiqui, as far as the interpretation of judgments, what has been decided, you can give a lecture in a law school. Here the full court of Pakistan is sitting. We don't want to be given a lecture on precedents. We want to be enlightened by the understanding of the Constitution, which we keep saying is an organic thing, pulsating, evolving, catering to all sorts of situations. I mean, if you're just going to be stuck with the case law, then we should just take a lecture in some law school.
My answer is...
There is no constitutional input then coming.
My answer is that there is nothing in the Constitution...
The context of that, what you're citing from that judgment is legislative intervention. But the problem is not whether the Chief Justice is the master of the roster. That is not the context of what we are considering now. The context is, and let me therefore ask you the question which I have asked Mr. Salahuddin and Mr. Zaid Ibrahim.
I thought if we talk about which question comes first, now another question has been put on another question. Can you answer mine and we get on with it, and another question can be asked. So please don't mix up my question with other questions. You respond to my question. Let another question be asked after you've given an answer, or you can keep your answers safe till you finish your submissions.
My Lord,
I don't want my question to be added on to when I have a clear-cut question. Hopefully you've understood it. If
yes,
you haven't, I will explain it further.
Yes.
Thank you.
If I may answer that question.
Sir, I thought you'd finished with your answer.
No, sir. Thank you. Sir, my answer is that reduce...
Never take my permission.
सर
डबल स्टैंडर्ड
नहीं सर आप मुझसे
सवाल लाइन टू नोट आगे बढ़े
बड़े सवाल कम पूछे इसलिए मैं रिलैक्स्ड हूँ
Are you taking the permission from...
चलिए आइए आगे बढ़िए
सर जी sir, there is nothing in the Constitution which equates the Chief Justice with the Supreme Court. And what has this law done?
Why don't you say so? End of story. What's more to be said?
Sir, what is this law?
Sorry. Is this your answer?
नहीं आंसर हुआ है, बात तो कर लीजिए, बात कर लीजिए फैसल सिद्दीकी साहब. मैं सबसे आज मैंने सबसे कम सवाल पूछे. सिद्दीकी साहब मैंने आज सबसे कम सवाल पूछे. कम से कम यही राइट मास्टर ऑफ द रोस्टर को दे दीजिए प्लीज.
इसका जो कॉन्टेक्स्ट है ना वो बात का वो ये है जो मैंने सवाल उनसे किया था अपना सलाहुद्दीन साहब से, जाहिद इब्राहिम साहब से, दिस लॉ आप तो इसको बड़ा रिस्ट्रिक्टेड कर रहे हैं ना, बट व्हाट दिस लॉ डज इज इट मेक्स पार्लियामेंट द मास्टर ऑफ द रोस्टर फॉर द सुप्रीम कोर्ट ऑफ पाकिस्तान. इसको ये असर इस सवाल का आप जवाब दीजिए.
माय लॉर्ड, देयर इज नथिंग
जवाब दीजिए पहले साहब के सवाल.
देयर इज नथिंग इन दिस लॉ व्हिच मेक्स पार्लियामेंट द मास्टर. I mean, what has happened to the Chief Justice under Section 2? Has his role been eliminated? No. He is one of the members of the committee.
No, you're missing the point. You were present.
आप अपना जवाब तो सुन लेना आपका पहले. आप जवाब दीजिए, please.
Sir, in terms, because there is no constitutional provision which gives this elated position to the Chief Justice, and the Chief Justice is equated with the Supreme Court. For example, giving the power of the constitution of benches to three senior most judges, how does that violate the independence of the judge?
I'll tell you.
आप तो complete कर लें please.
Because it is that committee is the creation not of the full court, but
मैंने आपसे 2-3 बातें और भी पूछी थी. अगर चीफ जस्टिस फुल कोर्ट ना कॉल करे, अगर चीफ जस्टिस कुछ ना करे, तो फिर पार्लियामेंट ने कर लिया एक काम, ठीक है, मुझे करना चाहिए था, नहीं किया मैंने, तो किसी दूसरे ने कर दिया, तो अब वो कॉम्पिटेंस है. तो अगर मेरे ही में कॉम्पिटेंस है, चलिए वो बात भी मान लेते हैं, नहीं है तो फिर इसका मतलब एक लॉक जैम हो गया, क्योंकि चीफ जस्टिस ने कहा मैंने तो करना नहीं है किसी सूरत में, और मैं किसी और को भी नहीं करने दूंगा. तो बुनियादी बात तो यहीं आके ठहरती है ना. अब सादी बातों को सादे अल्फाज में बयान करते हैं ना. इतने जजमेंट्स ये पहले इशू आया नहीं था सुप्रीम कोर्ट के पास, तो नया इशू है. तो आप ज़्यादा आइन को मद्देनज़र रखते हुए उसकी तशरीह कीजिए ना। अगर हम आइन की तशरीह सिर्फ जजमेंट से करने बैठें तो फिर हम एक टेक्स्ट बुक उठा लेंगे, पढ़ लेंगे, उसमें वकीलों की ज़रूरत नहीं है, उसके कॉन्स्टिट्यूशनल लॉयर्स की भी ज़रूरत नहीं होगी। आप कहिएगा फलां आप पढ़ लीजिए बुक ऑन कॉन्स्टिट्यूशनल लॉ, आपको सारे जवाब मिल जाएंगे। नहीं, वहाँ जवाब नहीं मिलेंगे, क्योंकि अब जो चीज़ें हम अब देख रहे हैं वो पहले नहीं देखी गई थी, और हो सकता है पहले गलत देखी गई हों, ये भी मुमकिन है। तो अपना विजन खुला रखना चाहिए, बेशक वो मेरे खिलाफ बात हो या मेरे फेवर में हो। इधर तो मैं अपने फ़ायदे की बात नहीं कर रहा हूँ, जो आपको इसमें कोई रुकावट होना चाहिए कि आप चीफ जस्टिस के सामने खड़े हों और चीफ जस्टिस कह रहे हैं कि आप मेरे इख्तियारात में कमी ला रहे हो, तो आप हिचकिचाहट क्यों, आपकी तरफ से क्यों ये हिचकिचाहट
नहीं, मैंने तो क्लियरली स्टेट।
निगरां वज़ीर आज़म अनवारुल हक काकड़ एक रोजा दौरे पर कोयटा पहुंच गए। कोयटा इंटरनेशनल एयरपोर्ट पर बलूचिस्तान के गवर्नर मलिक अब्दुल वली खान काकड़, निगरां वज़ीर आला मीर अली मर्दान डोमकी और निगरां वफाकी वज़ीर दाखिला मीर सरफराज बुगटी ने उनका इस्तकबाल किया। इस मौके पर चीफ सेक्रेटरी बलूचिस्तान शकील कादिर खान और IG पुलिस बलूचिस्तान अब्दुल खालिक शेख भी मौजूद थे।
निगरां वज़ीर आज़म अनवारुल हक काकड़ से निगरां वज़ीर आला बलूचिस्तान सरदार अली मर्दान खान डोमकी की मुलाकात। नेशनल एक्शन प्लान के निफाज के लिए मुनक्किद होने वाले एपेक्स कमेटी के 14वें इजलास से मुतालिक ब्रीफिंग। सूबे में अमन व अमान की मौजूदा सूरत हाल पर गुफ्तगू। मुलाकात में निगरां वज़ीर दाखिला मीर सरफराज अहमद बुगटी भी मौजूद थे।
डॉलर की कदर में गिरावट का सिलसिला जारी। इंटरबैंक में डॉलर मजीद ₹1.16 सस्ता हो गया। इंटरबैंक में डॉलर ₹280.49 पर पहुंच गया। गुज़श्ता रोज इंटरबैंक में डॉलर ₹281.65 पर बंद हुआ। स्टॉक मार्केट में तेजी का रुझान। 100 इंडेक्स में 400 से ज्यादा पॉइंट्स का इजाफा। दौरान ट्रेडिंग 100 इंडेक्स 48,000 की नफसियाती हद उबूर कर गया।
Of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about that it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. Yes. So whether at all it becomes part of a procedure of practice and procedure rather than as a substantive.
I think this note opens up that question. If I may just read the last paragraph and then Your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case, and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If Your Lordship may kindly see page 25, para 12. Para 12. Ji sir, ji sir. Ji. Page 25. In view of the above discussion, I am in no doubt that the question referred to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. उससे ऊपर जो है 4 लाइनें वो है in contrast. My learned colleague Sayyid Hassan Azhar Rizvi has rightly noted in an order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
See, Mr. Counsel, the thing is that you are, of course, referring to my order.
Yes, sir.
It is an order of the court, and therefore it is for others to make of it what they will. Yes. It is not for me to now read and interpret it, but I am picking up on the point that you think flows from this order.
Ji.
Seems to me, with respect, that it cannot conceivably flow from this order. The reason is that in the issue before the court or before me as the referee judge was a right of appeal conferred by statute right? And as you have read, I have noted two kinds of appeal and the jurisprudential aspect of it and the language of entry 3 of the current list and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, would, and that is certainly not what this order was about, but would be incorrect. Why? For two reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I think it can.
There's just one more. Yes. Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My Lord,
in relation to Section 5 now, we are in the context here is Section 5.
Lord.
So tomorrow the full court amends the Supreme Court rules.
हमारे पास जितने केसेस बढ़ते जाएं हम फैसला करें, ना केस एक केस सुने दिन में 50 केस सुने, हमारी मर्जी है, ठीक है? नहीं, सॉरी, इस तरीके से नई चीजें चल सकती हैं। हर अदारा को खुद एहतसाबी करना होगी सबसे पहले, इससे पहले कोई और उसकी एहतसाबी करे। तो पता नहीं, ये सीधी सीधी बात है, अब सीधी सादी बातें करें। अब केसेस में हमें उलझा करके घंटों चल रही है बहस, मतलब
frankly, when I look at Section 2, I see no violation of the independence of the judiciary. Yes, if that principle that under no circumstances Parliament can ever say anything about constitution or benches, then of course, then Section 2 goes. But I don't think, if anyone can point out any element which violates the independence of the judiciary in terms of the committee, and it is a misnomer that the Chief Justice is no longer a part of the constitution of the bench. He's one of the members. His role has not been eliminated. I move on to the second one, which is the most difficult one, which is, and Justice Shahid had asked a very important question about framing rules, framing rules. And I've dealt with that in my note. Your Lordship may have a look at that. But I'll move on to the second. But that's a very important question. There is no provision which says that rules should be framed. It says determining procedure, and I've tried to answer that in my note. Thank you, sir. Sir, 3. Now, it's a very important, this is the only provision which I would ask your Lordships to read down. This is the only provision.
Which is section?
Section 3, sir.
3.
What Section 3 does is that it says that there is this committee will at an initial stage look at whether these petitions are maintainable, whether the two conditions in Article 184(3) are present or not. Does it satisfy it or not? Now, this is clearly, as His Lordship Justice Mansoor has held, this is clearly a judicial adjudication. And this committee is really acting on the administrative side. It's obvious from the language of this provision. Now, there is nothing unusual, of course, about this initial, examination of these. The US Supreme Court does this. There is no hearing, there is no reasons at the leave granting stage. So the real problem is not that. The real problem is...
There is a problem here. With all due respect, your analogy is wrong. And I'll tell you why your analogy is wrong. The Supreme Court of the United States applies what is called the rule of 4.
Yes.
That out of the 9 judges,
yes,
at least 4 must agree to hear the case. That case goes to full hearing. But this scrutiny that you're talking about, that is not done by a committee of 3.
That is why I was going to add.
That is committee, because they all sit en banc.
No, sir, that is what I was saying. What is not unusual is no reasons and hearing is given.
No, that is not the problem with section 3.
Sir, मैं वही तो बता रहा हूँ. Your lordship is saying that when those 4 judges sit,
No, it's not the 4 judges. They have what are called conferences. I think every second Saturday they have a conference in which all 9 judges sit, and the cases are put up in conference. Any case that musters 4 votes out of the total 9.
Yes.
It's not a committee of 4 that sits. All 9 sit. The full court sits, what we would call the full court. That sits, and if 4 out of those...
and 5 when there is a grant of a stay order.
Sorry?
And 5 when there is a stay order. Yes.
आप तो सेक्शन 3 की बात कर रहे हैं ना?
जी.
तो अगर 4 जो हैं वो नहीं, 4 वोट उसको नहीं पढ़ते, what they call cert denied. ठीक है? So it's not that there's a separate committee. Whatever they do, because they have their own, because they always sit en banc. यहाँ पे मसला क्या आ रहा है कि 3 जो what my learned colleague Justice Mansoor Ali Shah has stated in a very clear statement of principle, that the power of adjudication cannot be in the hands of any administrative committee. The context in which my learned colleague gave judgment was registrar, but as a matter of principle, with all due respect, it doesn't matter whether it's a committee, no matter how eminent or senior those judges are, the problem remains the same. So the US example, I'm sorry, is not...
Sir, I was giving it for a different reason. If your lordship...
आप ये भी बता दीजिए कि अगर हम देखें एक मुल्क से दूसरे मुल्क के एग्जाम्पल्स हम देते रहते हैं, हम ये भूल जाते हैं कि अमेरिकन सुप्रीम कोर्ट में 120 केस से सालाना फैसला होता है. अगर आप सुप्रीम कोर्ट, अगर आप इंग्लैंड की बात करें तो फिर नंबर्स हमें दें. हमारा सिस्टम बिल्कुल फ़र्क है. हमारे सिस्टम में हर कोई सुप्रीम कोर्ट जब तक नहीं आता खुश नहीं होता है, या CPLA में आएगा या सिविल अपील में आएगा. वहाँ ये सिस्टम है ही नहीं, बहुत कम केसेस होते हैं. तो अगर आप हर केस पे बैठ करके फुल कोर्ट ये तयन कर सकता है, ये वाले सुन लें ना सुन लें, तो आप ये सारी बातें फिर बताइए ना. अगर आपको एक एग्जाम्पल दूसरी जगह से लगाना है तो फिर अंग्रेजी में कहते हैं कंपेयर एप्पल्स विद एप्पल्स एंड पेयर्स विद पेयर्स. ये तो नहीं हो सकता कि आप एग्जाम्पल ले लें और उधर तो जी 120 केसेस हैं. अच्छा, 120 केसेस में अगर पूरा अमेरिकन सुप्रीम कोर्ट बैठ के तयन भी कर ले तो कितना वक्त लगेगा? आप बैठ करके 56,000 केसेस को तयन कर लें, वो बात ही नहीं होगी, वो अलग बात है.
तो ज़्यादा होते हैं जी.
Let me clarify. Cases run in several thousand.
जी, several thousand.
Out of those only
जी
100 or
हमें देखिए जो चीज़ हमारे पास है नहीं, मुझे नहीं पता. अगर आप कोई चीज़ फाइल करें हम पढ़ लेंगे उसको.
The only reason I cited that, I agree with you.
Supreme Court की Wikipedia
I agree. I actually agree with you. What I'm citing it, the problem with the provision is not that reasons are not given or there is no hearing. The problem is this maintainability adjudication cannot take place on the administrative side by even a committee.
आप रिपीट कर रहे हैं बार-बार.
लेकिन इसका हल क्या है? इसका हल क्या है?
रीड डाउन करें.
इसको रीड डाउन कर दें और रीड डाउन इस तरह करें कि the scrutiny may take place, but whatever the petitions are should be put up with the scrutiny report to a judicial bench. This is the way to say. ये सिर्फ ये आपको करना है और not maintainable.
वकील साहब, आपने सेक्शन 3 पढ़ा नहीं है
जी.
उसका आखिरी पार्ट पढ़ें
जी.
आप जो रिपोर्ट की बात रीड डाउन करने की कर रहे हैं
जी,
इस सेक्शन का आखिरी पार्ट पढ़ें.
Sir, I'll read the whole. Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1 or Part 2 of the Constitution involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court, which shall also include the members of the committee for adjudication of the matter.
आप जो बात कर रहे हैं ना, which may include, तो ये आखिरी words जो हैं, they would need to be eliminated.
No,
obviously,
no.
Committee, so the three member committee वो इसको scrutinize करे.
Yes.
Say not maintainable, puts it up before a 5-member judge, of which
no. Why 5-member bench? 3-member bench? अभी सिर्फ ये वो केसेस पुट अप करेंगे
से मेंटेनेबल फिर
नहीं, यस ये तो हर सर चेंबर में अपील जाती है, इनिशियली एक डिसाइड होता है मेंटेनेबिलिटी का इशू, दैट डजंट बार द कोर्ट फ्रॉम डिसाइडिंग द मेंटेनेबिलिटी क्वेश्चन व्हेन इट इज पुट बिफोर अ जुडिशियल बेंच।
सवाल जो उन्होंने पूछा वो ये है कि अगर फर्ज करें ये कह दें कि नॉट मेंटेनेबल,
यस,
देन व्हाट वुड बी द रेमेडी अवेलेबल टू द एग्रीड पर्सन?
अगर वो कह देते हैं नॉट मेंटेनेबल, आई वुड से दिस इज व्हाट योर लॉर्डशिप हैज, इसमें सिर्फ ये कहा गया है कि जो मेंटेनेबल होगा वो बेंच के पास जाएगा।
नहीं नहीं, अगर फर्ज करें वो नेगेटिव में उसका वो कर दें,
तो फिर भी बेंच के ऊपर पास जाएगा सर,
सही जाएगा, कहाँ लिखा हुआ है?
सर यही तो रीड इन करना है, यही रीड इन करना
बात सुने, उसमें ये भी लिखा
है,
हुआ
यही
है
रीड इन करना है,
which may include members of the committee.
Yes.
So notionally, it can go before the same judge again.
Yes.
And this time you would expect them to hold that it is maintainable.
सर फिर तो रिव्यू jurisdiction भी खत्म कर देनी चाहिए।
नहीं, मगर दूसरी बात है कि अगर ये कानून,
I think there's a simple solution to this.
देखिए उसको सॉल्यूशंस ढूंढने से पहले जो मौजूदा निज़ाम है इस कानून को एक तरफ रख दीजिए। इस मौजूदा निज़ाम में कैसे होता है, देखिए साहब इधर भी थोड़ी सी तवज्जो दे दें कभी कभी।
नहीं सर, आप प्लीज शर्मिंदा पे शर्मिंदा
नहीं तो आप देख कहीं और रहे हैं, तो जरा ये देख लीजिए मौजूदा निज़ाम में अगर ये एक्ट तसव्वुर कर लें कि नहीं है बना, अब 184 की आई थिंग, अब तो वो ब्रांच में लिखेगा नॉट मेंटेनेबल, यही लिखेगा ना, या पुट अप कर देगा कोर्ट में या लिख देगा, फिर उसकी करेंगे चेंबर अपील, ठीक है, फिर जज कह देगा द ऑब्जेक्शंस आर सस्टेन्ड और ओवररूल्ड। तो ये कहना कि ये जो निज़ाम आया है ये मौजूदा निज़ाम से ख़राब है तो एक अलग बात है।
नहीं, ये मौजूदा निज़ाम से बहुत बड़ी इम्प्रूवमेंट
अभी तो वो इख्तियार सारा उसके पास बैठा हुआ है, वो रजिस्ट्रार खुद भी नहीं कर रहा है, वो कोई सब डेलीगेटेड पावर एक्सरसाइज कर रहा है जो पता नहीं जो पिटीशन एंटरटेन कर रहा है, ठीक है, और वो बहुत से लोग शायद अपील भी ना करें, वो भी चेंबर अपील है, वो अगेन वही जज अगर चेंबर अपील में उसने सपोज कह दिया वो कल बेंच में बैठ सकते हैं, क्योंकि वो एक और चीज तरह की नजर से देख रहे हैं, अब बेंच में बैठ के दूसरी नजर से देख रहे हैं।
All cases which go through scrutiny should be put up before a judicial bench. What is the issue?
फैसल साहब ये बताइए,
What is the issue?
फैसल साहब जी ये बताइए, क्या जो इसकी डिफिकल्टीज यहाँ पे अभी हाईलाइट हो रही हैं, आर वी empowered under Article 191 to amend our rules accordingly and remove these difficulties? The power vests in us.
बिल्कुल.
So there, I don't see any
I don't see how this provision is a threat to the independence. If all cases after scrutiny are put before a judicial bench.
Mr. Faisal, यहाँ पे एक चीज और क्लैरिफाई कर दीजिए। 191 के तहत अगर फुल कोर्ट की मीटिंग कॉल करनी है तो किसने कॉल करनी है? Where it is written? Who will call the full court meeting?
So that is to be called by the Chief Justice.
No, it says the committee now.
Where it is written?
So this is the practice.
Committee will, including meetings and constitution of benches with the committee now.
Sir, वो full court meeting की बात कर रहे हैं, not the constitution of benches.
तो इसका मतलब
Sir, that is a practice, your lordship.
नहीं तो practice
If the Chief
यही है
Justice
ना
doesn't
कि
want to
that is
amend
to
the
be done
rules,
by
then
the
other
Chief
judges
Justice.
can call the meeting and amend the rules.
Yes.
And they do it.
Sorry?
If the Chief Justice doesn't want to amend the rules, then the other judges can call the meeting and amend the rules.
Sir, these are very difficult questions which I need to really think
आपके
about.
सामने एक सिचुएशन चीफ साहब ने रखी है
जी बिल्कुल
कि अगर मैं केस फिक्स नहीं करता तो क्या रेमेडी होगी आपके
सर
पास?
मुझे इन सवालों
the other judges would be silent spectators. Can they call the convene the meeting and amend the rules?
कॉन्फ्लिक्ट्स है within judges, इनके बारे में
इसका जवाब इसी लेजिस्लेशन में दिया हुआ है। 2 सबसेक्शन 2 पढ़े।
वो कमेटी की मीटिंग है।
फिर वो कमेटी, वो कॉन्स्टिट्यूशन ऑफ बेंचेस
इसके ऊपर जब शुरू करेंगे तो उसमें कौन सी चीज रहेगी है? एवरी कॉज, अपील, मैटर बिफोर
एडमिनिस्ट्रेटिव साइड पे
ये सब कुछ हो जाएगा।
नहीं सर, ये जुडिशियल कॉन्स्टिट्यूशन ऑफ बेंचेस हैं, उनका सवाल
वो सवाल ये है कि इसमें कौन सी चीज है जो इसमें ओमिट की गई है।
Sir, I wouldn't like to read matter as involving full court meetings.
ना ये पहली दफा सिचुएशन अराइज हो रही है, जैसे अभी पॉइंट आउट किया गया, तो उसको हम एग्जामिन कर रहे हैं, तो वी नीड योर असिस्टेंस. व्हाट इज योर व्यू पॉइंट?
फुल कोर्ट कॉल करने का तो वैसे भी रूल्स में तो कोई प्रोविजन नहीं है.
कोई प्रोविजन नहीं,
बिल्कुल नहीं.
दिस इज प्रैक्टिस.
देखिए साहब
जी,
लाइटर नोट, इतने पैसे क्लाइंट ने नहीं दिए.
अब मैं अपने आप को शर्मिंदा नहीं करना चाहता. These are very difficult questions, my lord. I really have to think about that these conflict within judges, how are those to be resolved, whether writs are to be issued, what are the other mechanisms. These have no easy answers. मुझे इस केस के ऊपर सोचते हुए इतने हफ्ते लग गए. I think what your lordships are taking will take me 6 months to really think about.
Mr. Siddiqui, हमने सुना है कि you are a sportsman. कभी कोई टीम ऐसी देखी है जिसके 3 कप्तान और वो जीती हो?
And Mr. Siddiqui, you can ask for the in-camera proceedings.
वैसे सिद्दीकी साहब, स्पोर्ट्स से मेरा भी ताल्लुक है. कप्तान और वाइस कप्तान जरूर होते हैं.
सर सुप्रीम कोर्ट में होपफुली कप्तान भी होना चाहिए. सर लेट्स मूव ऑन. आई जस्ट रनिंग थ्रू.
सिद्दीकी साहब, कैप्टन एक ही अच्छा लगता है.
Sir, Section 4, sir. Section 4 says that whenever an interpretation of constitutional provision is involved, a bench should not be less than 5. I think
that is again a dictation.
My lord, I mean it is.
Shall not be.
My lord, it's.
Why can't the committee say, well, this is an important matter?
But how will that affect? If there is a substantial question of law,
I don't have a question of how will it affect. All along my question is, who is saying it? Who is constitutionally competent to lay down this principle?
If
this rule can be laid down by the court in its rules, and
if Parliament has legislative,
in terms of its rule-making powers under 191.
Sir, if Parliament has legislative power, then your lordship has to see whether this rule violates the principle.
That's a big if.
Yes. If Parliament has no legislative power, then this law goes, this provision goes. Otherwise, one looks at this provision.
Mr. Faisal, according to you, the Parliament has the legislative.
Yes. And the only
move on. According to you, Parliament has the power. We will decide whether Parliament has power or not. Now move on.
ये clarity इसमें सिर्फ ये.
If the Parliament, if we come to the conclusion that yes, of course, Parliament has the power to make a law, then in law the Parliament may use the word may or may use the word shall.
But even Parliament cannot make a law which will destroy the power of the Supreme Court to make rules and violates the independence of the court.
Okay, so tomorrow the Supreme Court full court says, well, we think 5 judges are not enough, or 5 judges are too much. We want to make it 3. Can they do it?
Yeah. In terms of this, in the presence of this law, they cannot.
Yes.
Yes.
So that means a power of this court has been trumped by a legislative instrument.
Sir,
the
question should be what fundamental rights or independence of the judiciary has been violated. The only thing was that it's a bit badly drafted. The term is actually a substantial question of law involving interpretation. यही term use हुआ है Article 185(2)(f) में.
चलिए देखिए कोई नई बात करें तो फिर दूसरों को सुन लेते हैं.
एक सेकंड, एक आपने क्या दिया, 3 को रीड डाउन कर दें.
सिर्फ 3 को.
ठीक है. 4 is badly drafted. अभी हम 4 पे आए हैं, अभी आगे 5 से you have an uphill task.
No, but sir, the point is, this is has ever a law been struck down because of bad drafting?
No.
Or being impractical?
A law can be struck down on various grounds.
Yes.
One of which is it is vague, it is unclear, it is
not
beyond,
on bad drafting.
It is beyond legislative competence.
But not on bad drafting. अब एक criminal lawyer ने ये law बनाया तो वो constitutional problems तो कुछ होंगी sir. Sir, Section 5, sir.
Is that a confession? You are saying it behind his back.
Sir, मुझे तो यही समझ में आता है.
नहीं ये ना करें.
Now I come to the main question, which is this problem of a full court and there being no appeal. and the problem that if there are 8 or more, if there are 9 judges, there would be no appeal.
नहीं, मगर इससे पहले तो आप ये तो आपने गिवन कर लिया प्रॉब्लम है। देखिए ये ऐसे ना अप्रोच, आप देखिए मौजूदा सूरत हाल में बेहतर थी खराब थी, ये तो कहना ये प्रॉब्लम है कि फुल कोर्ट हो गया तो अपील नहीं है, तो फिर आप इस कानून
इसका जवाब दे रहा हूं।
नहीं, जवाब नहीं होगा, ये क्वेश्चन हो ही नहीं सकता है। मैं बता रहा हूँ क्यों नहीं हो सकता है। सवाल इसलिए नहीं उठेगा,
सवाल तो वैलिड है।
जरा सुन तो लीजिए ना, आप समझने की कोशिश कीजिए ना। मौजूदा सिस्टम क्या है, इस कानून को एक तरफ रख दीजिए, आप जरा तवज्जो दीजिए।
जी जी,
मौजूदा सिस्टम ये कि इस कानून को 1 मिनट एक तरफ रख दीजिए। जी, अब कौन सी अपील है ही नहीं ना। तो अब आप कह रहे हैं ये कानून जो आया है 99% खामियों और परपोर्टेड खामियों को दूर करने के लिए, वो इस लिहाज से बुरा है क्योंकि वो 1% केसेस जिसमें फुल कोर्ट होगा कोई अपील नहीं है। तो पहले तो फिर अगर आपका ये बात मान ली जाए तो आप फिर तो आप ये कह रहे हैं, आपकी बात में ये इम्प्लाइड है कि ये कानून दुरुस्त है। अब आप 1% के लिए भी अपील प्रोवाइड कर दें तो फिर ये निकलेगा, या तो आप कहेंगे कि जी 99% तो मसला सॉल्व हो गया, 1% कराएगी।
मैं यही बात कहूंगा कि द मेयर फैक्ट दैट देयर इजंट एन अपील इन सर्टेन कैटेगरी ऑफ केसेस would not make the law unconstitutional.
They may most certainly be a difference of opinion. One person can think that this is not relevant, but I think that it is very relevant, because when the law gives a right of appeal and the committee has the option of taking that right of appeal away, then it is relevant to the person whose right of appeal has been taken away. If we recognize appeals as being substantive, then that so-called arbitrariness that is being controlled, I don't see how it's being controlled. Because किसी को right मिलेगा, किसी को right नहीं मिलेगा. Again the question will be, ये कैसे decide होगा? Again we'll go looking and hunting for principles, कि कौन सा principle apply करें. So on the face of it, it means that either you can't ever constitute a full bench, you can't constitute a bench which is more than 7 or 8 members, that's it. You're not allowed to do that. Because Parliament has said appeal होनी चाहिए, और appeal होनी चाहिए का मतलब है that every order of the Supreme Court under 183 has to have a right of appeal. It doesn't mean that I have the option to choose कि अब full court बैठ गया तो सब अब कोई फर्क नहीं पड़ता क्योंकि सब ने केस सुन लिया. Right of appeal is a right of appeal, which we've heard at length yesterday, how we recognize that right of appeal, how Islam recognizes that right of appeal. So यहाँ कैसे हम वो right ले लेंगे वापस and कहेंगे नहीं यहाँ नहीं है क्योंकि हम सब बैठ गए.
Mr. Faisal, if you look at to me it appears to be an intra-court appeal.
Yes.
So at the High Court, if the larger bench is constituted, there's no intra-court appeal.
Sir,
so if there's a larger bench, there's no appeal.
There are 3 restrictions on an appeal from a single judge in an intra-court appeal.
अच्छा, ये इसमें एक और बात अगर आप मद्देनजर रखें, हम अगेन realm of conjecture,
सिंगल बेंच इस वजह से जब डीबी सुनती है या 3 जज सुनते हैं तो इसलिए उसकी अपील नहीं जाती. लॉ रिफॉर्म itself provides an answer. The appeal provides where a single judge decides the question.
जी मैं
1 मिनट आप सर जी
देखिए, हम कंजेक्चर समाज से भी बात कर सकते हैं. अब आप मुझे बताइए आखिरी इस फुल कोर्ट से पहले कौन सी फुल कोर्ट थी?
I think 2015 सर.
कितने साल गुजरे?
जी 8 साल हो गए.
तो हम उस केस के लिए सिर्फ फिक्रमंद हैं या हम फ्यूचर के लिए फिक्रमंद हैं? 2 बातें हो सकती है ना. एक तो पिछले के लिए हम फिक्रमंद हैं कि वो केस में वो जो 21वीं अमेंडमेंट टू द कॉन्स्टिट्यूशन है वो एक राइट ऑफ अपील सलब हो गई और वो नहीं हो सकती है. ठीक है, ये एक मफरूजा हो सकता है. ठीक है. दूसरा है कि नहीं, हम पिछले के नहीं फिक्रमंद हैं तो हम फ्यूचर के लिए फिक्रमंद. फ्यूचर की जब बात आएगी, जब एक्चुअल बात आएगी हमारे सामने, फिर हम अगर आप हमें इतना रिस्पेक्ट देते हैं कि हम आपस में कुछ समझ लेंगे इसको. हमें ये तो नहीं बताना है कि फ्यूचर में क्या होगा. हमारे सामने जो मसला आता है, और हमेशा ही कहा गया है, उसी मसले को हल करो जो आपके सामने आ जाए. अब क्या मसला होगा आइंदा, हो सकता है कभी फुल कोर्ट होना, हो सकता हो जाए, तो जब वो मसला आएगा फिर आपको सुनेंगे कि फुल कोर्ट बैठना चाहिए, 7 मेंबर बैठना चाहिए, 10 मेंबर बैठना चाहिए, वो सारे बातें इशू खड़े हो जाएंगे. अभी तो फुल कोर्ट एक ही बैठी थी, मुझे जहाँ तक याद है, आपकी बात सही है, 2015 में 21वीं अमेंडमेंट की. बात, उसके बाद तो फुल कोर्ट नहीं बैठी, तो ये आई है दूसरी दफा फुल कोर्ट
My
तारीफ में।
answer to the question. This is one way of
When legislation is framed, the legislators are supposed to look at all eventualities and try as far as possible to cater for them. Now, it is so obvious that there is this defect in this law. Was it debated? Was it thought about? Was there a thought process? And thereafter it was drafted, keeping in mind कि जी full अगर court hearing करेगा तो उसकी appeal नहीं होगी. And if it was thought about it, why was it not mentioned in the
my response would be,
so the obvious conclusion is that there is a flaw, and
there is no flaw.
Is so apparent.
There is no
that
flaw.
Everybody can see it.
No, there is no flaw. It's a self-contradictory question. When you say that there should be an appeal in the full court, no legislature in the world can provide an appeal.
Nobody is saying that there should be an appeal.
There can never be an appeal to the Supreme
You
Court.
have actually misunderstood.
It's a
No, Mr. Siddiqui, the question is not whether there should be an appeal in the full court. The question is simply that how will this right of appeal be exercised if you cannot constitute a larger bench because you have been stopped from doing so. Which means that when a full court, if the committee decides, whereas in this case, where a full court is sitting, if this law is upheld, that there is no right of appeal. So the question is simply this, that aapne block kar diya na right of appeal. What is the point of giving that right?
कोई legislature दुनिया का appeal दे ही नहीं सकता.
There is another aspect to it.
But I come to the 9 judges thing.
Actually, there is no answer to this question.
No, there is an answer.
We go around and put a full stop to it. कि जब full court में हम बैठ के, यानी कि हमने जब decide कर लिया full court, तो then there is no right of appeal.
ऐसी चीज की deprivation किस तरह मांग सकती है? हो ही नहीं सकती.
You have deprived someone something that the lawmaker thought was essential.
No, it's not a problem at all. It's not a problem at all.
But मैं कहता हूँ, अच्छा ये 9 member की
ये देखिए
एक सेकंड
सेक्शन 5 में लिखा हुआ है, सेक्शन 5 पढ़ लीजिए.
ये जो पावर है
राइट ऑफ अपील का, आपने
तीन जजेस की कमेटी को दे दिया कि किसमें वो राइट ऑफ अपील देंगे और किसमें नहीं देंगे.
सर मैं उसका जवाब दे दूं. मैं उसका जवाब दे देता हूँ. देखिए, full court I don't think even a right of appeal can be demanded. Now the issue is that in cases.
No, where does the law say that?
Sir, it is an impossibility. You cannot provide. 50 जज भी हो जाए किसी कोर्ट की, आप फुल कोर्ट की अपील किस तरह?
लार्जर बेंच बन नहीं सकती ना.
देखिए सदीकी साहब सुनिए.
The point that it has not even.
सदीकी साहब जरा देखिए इसमें
It has not even been debated.
अपील में ये बताया गया है कि the appeal shall be heard by the larger bench. ठीक. लार्जर बेंच के नंबर्स नहीं बताए कि क्या एक जज मजीद बैठ के लार्जर बेंच होगा, 2 जज मजीद उसमें होंगे.
लार्जर बेंच तो हो ही नहीं सकती ना. इसके अंदर जब फुल कोर्ट हो गया तो देयर इज नो लार्जर बेंच फॉर अपील.
सर सुन ले. लार्जर बेंच की प्रोविजन भी हो सकती है अगर ऐसी सिचुएशन आए.
It's a matter of interpretation by the court and it's sort
ये हम रूल्स में देख सकते हैं. इवन कॉन्स्टिट्यूशन में जरा, इवन कॉन्स्टिट्यूशन हमें ये इजाजत देता है, whenever there is need, as per the constitution, a judge of any high court can be called for a particular case. तो लार्जर बेंच बनाने
की इसमें भी हम रीड इन कर लेते हैं. ये इसमें भी हम रीड इन कर लेते हैं कि ऐसे करना ऐसे करना. तो आप 2 प्रोविजंस हो गए रीड इन, एक होगी बैडली ड्राफ्टेड, ऐसे ही करते हैं.
रूल्स में कर सकते हैं.
Rules cannot read down something which the legislature could never do.
Mr. Siddiqui, आप रिडंडेंसी तो इस अपील में रिडंडेंसी तो नहीं एट्रीब्यूट कर सकते ना. आपने अपील प्रोवाइड करनी है
नहीं,
एंड इन ऑर्डर टू अवॉइड रिडंडेंसी. अच्छा नहीं
करनी. बट लार्जर बेंच का मतलब ये फुल कोर्ट के ऊपर अपील नहीं होगी.
आगे बढ़े, आपका हमने मौके सुन लिया.
हो गया. लेट मी कंप्लीट. In order to preserve that right, in order to preserve the right of appeal, in essence, you can never constitute a full court.
Sir, because full court पे अपील हो ही नहीं सकती, तो you can always constitute.
तो आप उसको
in that case there will be no appeal.
Flipping the argument.
आगे बढ़े. सर आपका मौके सुन लिया, हमने कहा नहीं हो सकती. चलिए अगले बात बताएं.
Section 2 retrospectivity का इशू था. ये अपील दे दी गई है retrospectively. Sir, there are two principles which will radically reduce the right which has been given. The first was pointed out by Justice Athar. This is an appeal against orders passed under Article 184(3). If an order has been passed after that under review jurisdiction, the appeal will not lie. These are not orders which, that's the first thing.
एक second, does the law say this or this is your interpretation of the law?
Sir, 184(3) के orders है ना, अगर आपने review file कर दिया, उस पे review का order आ गया. अगर किसी को अभी किसी का review pending है and he wants to really have the right of appeal, he has to withdraw his review.
I mean, you see, there is no cut-off date of filing appeal. There is open-ended.
There is a cut-off date for filing appeal.
Mr. Siddiqui,
जब वो situation आएगा हम देख लेंगे ना.
Sir, second principle मैं बता दूं. Second principle.
अरे आप मफरूजों पे जा रहे हैं, वो what may or may not happen, but just tell us. देखिए, surely it boils down to one thing. Some of us think the law should be struck down because the right of appeal is not been extended to what will happen to the scenario when there's a full court. Okay, others think it doesn't matter. Fine. I'm just saying, can you strike down a law that it creates a right of appeal, but it is to be struck down only because in one given scenario there is no right of appeal?
And sir, no law can be struck down on the argument of floodgates. No law can
आगे बढ़े.
The second restriction is that in every retrospective law, your lordships have said that this retrospectivity will never apply to closed and past transactions और वो vested rights have accrued. Sir, 184(3) के 1% से कम cases होते हैं.
आप बात सुने.
आपने review निकाल दिया, आपने vested right निकाल दी, closed and past transactions. कितने केस बच गए?
कल ये argument हुआ कि इसको आप read down कर लें, and it actually means 30 days. Within 30 days of filing of the promulgation of this act, जो decisions आए हैं या before उसके आए हैं within 30 days, तब से वो limitation start होगी. लेकिन 1973 से या 1974 से नहीं होगी. ये भी argument आया और हमने note किया.
Sir, I'm not arguing. There is nothing wrong with this provision if these two principles are.
All right.
I'll move on.
Mr. Siddiqui, 184(3) is a constitutional provision
sir.
and it is original jurisdiction.
Ji, sir.
Appeal is continuation of the same.
Ji.
How a law which is legislative incompetence because of not being a constitutional provision that can be provided by a simple lawmaking power of the legislator.
I have extensively dealt. अगर आप मेरा note देख लीजिएगा उसमें.
It's your jerky motions
I just want to, क्योंकि बहुत वक्त हो गया है, अगर आप allow करें मैं जरा खत्म.
Simple बता दें आप.
It's your jerky motions that distracts judges. They don't get to concentrate on your arguments.
Sir, there is no bar under Article 184(3) that it bars that you can't create an inter-court appeal, and that has been done in other laws also. I mentioned two laws, the Law Reforms Ordinance, Constitutional Forum, appeal is provided.
That is an entirely different premises.
No, my lord, I think it is clearly, and that is what, when I had read the judgment.
It has been explained by Mr. Ijazul Hassan, and very thoroughly that has been explained.
My lord, I would beg to disagree. And then, of course, there is the appeal in the contempt of court order. But now I'll come to the most difficult part, and with the utmost respect to the benches, which is
incidentally for the third time you have said, I now come to the most difficult part. So,
you are moving stepwise.
Every section of this law is so convoluted and difficult that
I have stated the reason why the law is so difficult.
Every section is the most difficult part of your argument.
The most difficult part is that one never wants to say that, your lordship, there is a judgment which should be revisited. There are two judgments, and they have been rightly cited by the petitioner's counsel, my lord. One is the Bas Kakar case, where they have relied on certain principles of law and constitutional principles on the basis of which they seek the striking down of law. I will not go into the detail of this judgment, my lord. I'll just point out the pages, page 1993 to to 1995 deals with Section 8 of the Contempt of Court Act 2012.
ये कौन सा पास मोहम्मद वाला है?
जी, PLD 2012 Supreme Court 923.
923.
Now, my lord,
इसमें कौन बताइए?
Sir, 993 to 995.
993 to 995 इसमें क्या खराबी है?
Section 8 in the Contempt of Court Act.
ये कितने जजेस का?
सर मेरे ख्याल में 5 दिखाओ बेटा, 5 मेंबर
देने
1 2 3 4 5 थे सर।
अच्छा, इसमें ये पेजेस गलत हैं, क्यों?
नहीं, ये पेजेस गलत नहीं है, डिस्टिंग्विशेबल है। The reason is that if your lordships looked at Section 8, which was struck down, of the Contempt of Court Act 2012, which I have attached in my notebook, वो ये करता था कि एक जज ने कॉग्निसेंस ले लिया है एक कंटेम्प्ट का, और वो ये कहता था कि ये ट्रांसफर कर दे। चीफ जस्टिस ने कॉग्निसेंस ले लिया और कहता था ट्रांसफर कर दे। So it was really interfering in judicial orders. Now, when it came to the appeal, what the Supreme Court has done is that it has said that Section 19 में जो appeal है वो ठीक है. Those are pages 1000. Those are pages. वो दिखाना मुझे judgment दिखाना. It's para 82.
Para 82. ठीक है, पैरा 82 ठीक है, कोई फर्क नहीं पड़ता है।
एक मिनट,
पेज बता रहे, पेज नाम
1004
ठीक है, पैरा 82 हो गया, हम ढूंढ लेंगे।
पैरा 82 and after striking down the 2012 Act, that law is revived. Now, the problem with the appellate appeals provision in the 2012 law was कि सर उसमें लिखा हुआ था एक अपील फाइल होगी, वो किसी शो कॉज के खिलाफ, हर किसी के खिलाफ, और फिर फुल कोर्ट बैठे, सारे जजेस बैठेंगे। मतलब सारा पावर ऑफ कॉन्स्टिट्यूशन ऑफ बेंचेस ले लिया गया था, और उसमें लिखा था फौरन सस्पेंड हो जाएगी। So that was such an interference that though whatever has been said,
no, but can't you reconcile it by simply saying that in that case the parliament did something so extreme,
yes,
to protect people of a particular who have been, may have committed contempt, therefore the court found it necessary to intervene. Here maybe that they have not done something so extreme.
And the law was, I think, unconstitutional. So वो distinguishable है, provisions देख लीजिएगा. Now I come to the judgment which, with due respect, I think if the law is to be upheld, this law has to be revisited to a certain extent. If your lordship may kindly see, sir, this is called the Ghulam Mohyuddin case.
Citation देते हैं.
Sir, ये unreported है. It is 11th August 2023.
11th August, ये कितने member bench है?
Three member bench. नहीं, this is constitutional petition number 21, 22, 23 of 20. मैंने लगाया है वह सर अपनी पेपर बुक.
ये कहीं रिव्यू वगैरह में तो नहीं पड़ा हुआ है?
Sir, this is in review also.
रिव्यू में फैसला हुआ है?
नहीं.
तो फिर इसको पता नहीं मुनासिब है या नहीं बात करना है इसके मुताबिक.
Sir, there are passages in this judgment.
अगर इसमें देखिए, अगर हम फिर उसको रिव्यू को फिर रिडंडेंट बना देंगे.
Sir, वो बात, I think even if those passages are revisited, the judgment on its own would stand.
नहीं देखिए,
but there are passages.
नहीं फैसल सिद्दीकी साहब, दो बातें हैं. पहली बुनियादी बात है, अगर एक वो रेगुलर उसमें आया है हमारे पास रिव्यू में, जो राइट एक्सरसाइज है, उसको हमें बात नहीं करना चाहिए. अब जहां तक असूल की बात है, अगर हमने इस केस में जिस तरीके से भी फैसला किया, असूली फैसला किया, अब उसका शायद असर उस पर पड़े या ना पड़े वो तो एक अलग बात है, क्योंकि लार्जर नहीं वो हम देखें, उधर जाने नहीं चाहते हैं, तो इस केस का जिक्र ही ना करें, बेहतर.
My last point and then I will conclude, sir. Page 8.
One thing I need to add. This law, which is under challenge now, was promulgated on the 21st of April 2023. Or review of judgments law immediately after that, which is 26th of May 2023. And if you go through, compare both laws, they are a repeat of each other almost, except that in review they said कि जी review में वही grounds होंगी जो appeal में होंगी. And it was pointed out to the.
Sir, वो poem थी ना, try again वो.
उसका क्या बना?
Okay, you answered that.
उसका केस
You
का क्या
answered
बना?
my question. Try again. There was so much desperation.
नहीं, वो सेटिसाइड हो गया
जी.
उसमें भी रिव्यू है या नहीं है?
नहीं, ये वाला रिव्यू वाला तो
नहीं, ये जो दूसरा
नहीं, ये उसी की बात कर,
उसमें भी रिव्यू हुआ है या नहीं?
जी, नहीं सर, उसी की बात कर रहे हैं, उसी की बात की.
अच्छा, इसी में?
जी.
अच्छा, ओके. आई थॉट एक और केस
हुआ. जी. ये subsequently आया.
Sir, last point, which is page 8 of my note.
Whether last point is difficult or easy?
नहीं सर, ये सबसे आसान है. This might actually unite the court. Sir, if your lordship comes to the conclusion that any part of this law, let's say section 3,
don't throw the baby out with the bath water.
Sir, ये सारी जो प्रोविजंस है अगर आप देखेंगे तो इंडिपेंडेंट है. सिर्फ 3 और 4 का ताल्लुक है 2 से और किसी का ताल्लुक नहीं है. 3 or 4 refers to the committee in section 2. Even section 2, if it's upheld, and section 3 and 4 are not upheld, it will not make a matter. So if your lordship comes to the conclusion, I hope your lordships and ladyships don't, but then the doctrine of severability can be applied in this case. It couldn't have been applied in the 2012 case. I'm very grateful to your lordship for a very patient hearing. To all your lordships and to your ladyships.
Thank you. At least speaking for myself, I compliment you for answering or trying to answer all the questions to the best of your ability.
Thank you,
were well prepared.
Thank you, sir.
I'll add my voice to that.
You must thank us also. We made you exercise, lose calories.
Thank you, sir. Thank you. Very kind, sir.
अब कितने लोग रह गए? बता दें कौन कौन से हैं? कोई जो मुख्तसर वाले हैं, किसी ने आप कोई नई बात, क्योंकि काफ़ी तफसीली आपको फ़ायदा मिल गया. जाहिद इब्राहिम साहब और कौन थे, फैसल सिद्दीकी साहब का.
इसमें सबमिशन यही थी कि हमने प्रेस रिलीजेस भी इशू किए थे, रेजोल्यूशंस भी थी कि फुल कोर्ट की कंस्टिट्यूशन हो.
वो तो हो गया
माय लॉर्ड.
बगैर आपकी प्रेस रिलीज पढ़े हुए.
अच्छा. वो हमने सीएम लगाई हुई.
नहीं तो आपने जो बातें अगर लिख दी हैं तहरीरी तौर पे तो वो हम पढ़ लेंगे. अगर आपको कुछ मजीद कोई खास पॉइंट रह गया है जो इनसे छूट गया है तो बता दीजिए. नहीं तो काफी अटॉर्नी जनरल मेरे ख्याल में मेन आदमी शख्स होंगे.
इसमें सबमिशन यही है कि जो एक्ट पास
नहीं, आप इसको सपोर्ट कर रहे हैं एक्ट को. अच्छा, तो ये बताइए ये क्यों डिवीजन क्यों आया है वकीलों में? पाकिस्तान बार काउंसिल एक मौक़िफ़ ले रहा है, सुप्रीम कोर्ट बार एसोसिएशन दूसरा मौक़िफ़ ले रहा है. ये काफ़ी एक कानूनी बहस है.
लेकिन इससे पहले सुप्रीम कोर्ट बार ने जो रेजोल्यूशन और अपनी प्रेस रिलीजेस दी हुई हैं वो इसी पर्पज़ के लिए दी हुई हैं. वो अगर इजाज़त हो तो मैं पढ़ लूँ. माय लॉर्ड,
आपने फाइल की हुई है?
माय लॉर्ड,
नहीं, हम देख लेंगे. अगर फाइल है तो ठीक है.
अब ये
आपका सीएमए नंबर से बता दें.
आसान जवाब ये है, रीजनेबल माइंड्स कैन डिफर.
यस माय लॉर्ड. और इसमें सबमिशन यही है,
रीजनेबल माइंड्स. वो आप अपना सीएमए तो बताइए नंबर. पाकिस्तान बार काउंसिल ने क्या फाइल किया?
माय लॉर्ड 4207 8087
एक सीएमए नंबर
और 8087.
सॉरी, दोबारा आहिस्ता कहिए, एक शख्स बोले.
जी मैम. 4207 पहले है, ये अलाउ हुई है. और 8087
तो हो गई फुल कोर्ट. हाँ, अच्छा, ओके.
8087
दूसरी कौन सी है?
8087.
8087. हम आपको कब खत्म नहीं करना चाहते, मगर अगर वो बातें हो चुकी हैं, वो दोहराने वाली बात नहीं है तो फिर रहने दें.
मतलब इसमें सबमिशन सिर्फ इतनी थी कि जो एक्ट पास हुआ है उसमें सुप्रीम कोर्ट की पावर्स को इनलार्ज किया गया है, उसमें कर्टेल नहीं किया गया. और उसमें अगर एक जज साहब के पास ये इख्तियार था तो वो अब 3 जजेस साहबान के पास इख्तियार आ गया है. और अगर वो विद द कॉन्सेप्ट जिस तरह कुरान में भी है कि मशवरे के साथ अगर किया जाए, इसलिए कि पहले मशवरे नहीं होते थे, तो जिस वजह से हमने और सुप्रीम कोर्ट के फैसलों में हमने सफ़र किया है और ऐसे ऐसे फैसले भी हुए हैं जो कि सुप्रीम कोर्ट के जजेस साहबान ने, जिस तरह जुल्फ़िकार भुट्टो केस है उसमें नसीम हसन शाह साहब ने खुद एडमिट किया था कि जो ऑर्डर हमने किया था वो हमारी गलती थी और कोई प्रेशर था. तो इसलिए मेरी सबमिशन ये है कि ऐसे ऑर्डर किए जाएं कि जिस तरह आर्मी चीफ को ये भी इख्तियार दिया जाता है कि वो प्रेसिडेंट भी बने और आर्मी चीफ भी रहे, और 4 आर्मी चीफ जो हैं वो हमारे प्रेसिडेंट भी रहे इन यूनिफॉर्म. और इस बात का तल्लुक कोई किसी कॉन्स्टिट्यूशन से नहीं है. किसी कॉन्स्टिट्यूशन में ये मेंशन नहीं है कि एक आर्मी चीफ होगा और वो सिटिंग होगा और वो इलेक्शन लड़ेगा और प्रेसिडेंट ऑफ पाकिस्तान बने। इसलिए ये हमारी खुशकिस्मती है।
कहना ये है कि इंडिपेंडेंस ऑफ जुडिशरी पे इसका कोई असर नहीं, बल्कि
मतलब डेफिनेटली इसलिए कि प्रीवियसली जुडिशरी ने इंडिपेंडेंस व्यू नहीं दिया, इसलिए कि कॉन्स्टिट्यूशन में एक इख्तियार है ही नहीं है, तो वो भी दिया गया। और उन्होंने
आप क्या कह रहे हैं कि अपील का हक देकर के इंडिपेंडेंस ऑफ जुडिशरी बढ़ती है, कम नहीं होती है? ये
बढ़ती है माय लॉर्ड।
अच्छा,
इसलिए कि अगर वो राइट दिया गया है, अगर एक जज साहब के फैसले से कोई सफर करता है तो वो 3, 5 और 9 और इस तरह सुने,
आजाद अदलिया।
तो इसलिए मेरी सबमिशन ये है कि जिस तरह प्रीवियसली हो गया है कि जफर अली शाह केस है, उसमें फुल बेंच ने ये ऑर्डर फरमाया हुआ है कि आप चीफ एग्जीक्यूटिव ऑफ द कंट्री भी हो गए, आप कॉन्स्टिट्यूशन भी अमेंड कर सकते हो और आपने राइटली एक पॉलिटिकल और डेमोक्रेटिक गवर्नमेंट को डिसॉल्व किया। तो इस तरह के अगर फैसले होंगे तो हम आगे फ्यूचर में नहीं चल सकेंगे। मेरी सबमिशन सिर्फ इतनी है कि फैसले ऐसे किए जाएं वो जो कौम को और दुनिया को नजर आए कि वो जुडिशरी ने फैसले।
तो आप समझते हैं कि इस तरह हो कि आज़ाद अदलिया तो हो लेकिन कानून और आइन के पाबंद,
आइन के पाबंद। ठीक,
थैंक यू।
यही मेरी सबमिशन है।
ठीक, शुक्रिया। आपको कितने लोग रह गए?
आर्ग्यूमेंट्स हो तो ऐसी।
Is it short or is it long?
I'll try to be short. I've already had audience on the first hearing. I have filed written submissions and additional submissions, but I'll try to conclude my submissions in 1 hour, not more.
Who would leave you to conclude your arguments in 1 hour?
Not so.
You will be bombarded with questions now.
You can't get away that easy. No.
I said 1 hour for me.
कल आप हैं इधर?
I am.
कल कोई मेरा केस तो नहीं है, कोई बड़े वाले कोई पंचेस एक रखा था ना बहुत बड़ा? हाँ, तो कल फिर खैर में आप भी जरा फ्रेश हो जाएं, हम लोग भी जरा फ्रेश माइंड्स के साथ बैठेंगे। अगर आपको अगर if you're here, you're not going.
I've noticed that in the first half an hour one can get away with questions and make substantial progress.
You're going to regulate us.
Today I noticed it.
Are you going to regulate us? Are you going to tell us how we are going to conduct ourselves?
I'm just hoping this is an expectation.
It's a hope against hope. It's not going to happen.
Regulating the Supreme Court appears to be the unthing these days.
Not
flavor of the day.
Okay. अच्छा, आगे सर।
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट की समाअत आप मुलाहिजा कर रहे थे नाजरीन। ये समाअत के हवाले से आपको बताते चलें कि चीफ जस्टिस काजी फायजा की सरबराही में फुल कोर्ट समाअत की जा रही थी, जिसका आज के लिए ये समाअत जो है मुकम्मल कर ली गई है। अब कल दोबारा से ये समाअत जारी होगी। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों